Good morning, colleagues. Welcome to the webinar. Before I start, please give me a thumbs up if you can hear my voice. I just want to make sure you can hear. Much appreciated. Thank you so much. Good morning, property practitioners, and welcome to today's webinar. My name is Naledi. I'm the Stakeholder Relations for PPRA. I'm responsible for bringing you the education and training and awareness in respect to the webinars, conferencing, workshops, and more. And I'm very thrilled, for this webinar today because it involves all the categories we have in the legislation. And today's topic is incredibly important because anyone who's involved in the property sector, they will want to be interested with what Advocate is going to present for us in registering property practitioners under our new act. She's going to highlight the steps in ensuring compliance and professionalism within the industry. Okay, let me accept other colleagues. Today with me, I have Advocate Vile. Advocate Vile, I'm sure we've seen her, we've heard her voice in the webinars, we've encountered her in the emails. She's been presenting for us the whole of September, how to register. We also met with other categories in the past weeks. So Advocate Vile, who is she? She's the Executive Manager of Licensing and Exemptions Department here at the PPRA, and she's also the Fidelity Fund Claims Manager. Advocate Vile obtained her BA Law and postgraduate LLB degree at the University of Natal, and she has 38 years of experience as an admitted advocate. She spent more than 20 years as a prosecutor, criminal and civil magistrate with the Department of Justice, and 11 years in private advocate practice dealing with all areas of civil law. She's an expert as well in litigation, legislative compliance, and civil liability. She also acted here at the PPRA in enforcement and compliance as an executive, but currently she's wearing a cap of registration and licensing executive acting manager. She's going to take us through, on how and the requirements that will guide you to be compliant. And I'm sure you have a lot of questions. So what we are going to do now, I already see the hands. We are not going to take the hands now. We're going to allow Advocate Vile to give her presentation. Once she's done presenting, we will recognize the hands. I will monitor the questions that are going to be on the chat. You're going to be allowed to engage her. I'm going to unmute you after she has presented. Then we can have a conversation on this after that and take other questions. And we must also remember that for educational questions or CPD or research or legal, you can still send us the question on the chat, but Advocate Vile, she will not be able to respond broadly on that. I will forward it to the relevant department, but do send us your questions on the chat. And I'm not going to waste time. Please let's welcome Advocate Deborah Vile to give us a presentation. Advocate, you can unmute yourself.
Thank you, Naledi. Good morning, everybody. Just to check to see if everyone can hear me.
Yes, Advocate, we can hear you. There's
Perfect.
thumbs up, they can hear you.
Thank you very much. Welcome, everybody. And it's a pleasure to be able to share the webinar with you and provide the slides, answer some questions, and assist those who want to commence with the new registrations protocol, which applies under the PPA Act. So let's start, first of all, by advising that what we're going to do today is have a brief overview of some of the important aspects of the PPA, as well as going through the process of registration and licensing, which would apply to the various categories. As you will be aware, the Property Practitioners Act came into being in 2019, but it was only brought into effect by gazetting as from the 1st of February 2022. So from that stage, we have been developing our systems and onboarding the various categories of property practitioners, which the Act provides for. So these are the 12 categories of property practitioners which we regulate under the PPA. You will be aware that the old Estate Agent Affairs Act was replaced by the Property Practitioners Regulatory Authority, who regulates all these different sub-industries or categories within the property practitioner industry. Excuse me. So you will see we have estate agents, which have always been registered, and those are registered via our systems. Auctioneers, bond and bridging finance originators, HOAs who perform property practitioner activities, managing agents, property facilitators and intermediaries, business brokers, including sales of franchises and business undertakings, developers who market and sell their own developed property, timeshare and fractional ownership practitioners, property advertising platforms, property practitioners who specialize in collecting and distributing trust monies in terms of Regulation 2.4.1, and those are known as payment processing agents, and attorney employees who we have always registered and regulated. So I'm going to stop at one or two of them that might need a little explanation. So just briefly, HOAs who perform property practitioner activities, those are homeowners associations and other community schemes who operate in a way that to some extent they perform property practitioner activities as defined under Section 1 of the Act. So some of the HOAs have their own estate agent type forum where they advertise properties, they market them, they take a commission or a percentage from the sale, and those ones are basically the ones who fall within our jurisdiction. Managing agents, you will recall that under the old Estate Agent Affairs Act, managing agents were required to register with us then as estate agents only if they operated body corporates. So if they managed body corporate property, then they had to register with us. And that was by way of a directive from the minister in terms of her powers under the regulations. Currently, all managing agents are now included, whether they are managed body corporate, share block schemes, timeshare, holiday letting, anything else. Where you have managing of property or any right, title, or interest in the property, you fall within the definition of a managing agent. Property facilitators and intermediaries, those who sell property or facilitate the sale of property, those who act as intermediaries in those kind of transactions, also fall into the categories of property practitioners for purposes of the Act. Business brokers are clear. Developers who market and sell their own developed property. This is important to note because developers are now brought into the jurisdiction of the PPRA only if they not only build and physically develop their own property, but they also market it and sell it. So in other words, they do their own marketing, they do their own sales, they don't make use of a registered property practitioner to do that. So those developers who are simply builders, who do the building and all the marketing and property practitioner activities are farmed out to registered property practitioners, estate agents or managing agents or whoever, they don't need to register with us. And then number 11, those property practitioners who are known as payment processing agents, these are your pay props and those type of entities who have to register as a payment processing agent with us. They operate trust accounts on behalf of estate agents to relieve estate agents and other property practitioners of that burden. But they have to comply with a large number of requirements from our audit department in order to register and operate as a payment processing agent. Attorney employees, we have always regulated, as I said, and please note that attorney employees is specifically defined in Section 1 of the Act. We do not register attorneys. And just to clarify on the issue with attorneys and their registered articled clerks, those who are articled to them in terms of the LPC legislation, are exempted from registering with us if they perform property practitioner activities that arise in the course of their legal practice. Also, if that is done from the premises of and in the name of their legal practice. So attorneys are therefore exempt. They can do things like advertise for proper sale of property for a deceased estate or an insolvent estate or in execution of a judgment which would arise in their ordinary everyday legal practice. As soon as an attorney wants to operate outside of his practice or wants to operate and perform functions which do not arise within the course and scope of his legal practice, he must register with us, not as an attorney, but as a property practitioner, and then he falls within the ambit of this Act. We'll move on then to the Licensing and Registration Business Unit, which licenses and registers all property practitioners. There are our functions: the registration and licensing, the renewal of Fidelity Fund certificates of all property practitioners by the 31st of October of the year in which the practitioner's FFC expires. Exemptions in terms of Section 4 are also dealt with by us. In terms of Section 4, property practitioners can apply for an exemption from any specific section of the Property Practitioners Act, and it's done by way of the E1 form, and it's sent to that address, and I will deal with that a little more a little later in the presentation. All FFCs are valid for 3 years, unless the first year is your first FFC, in which case the first year constitutes the remainder of the year of your first registration, and it's valid from the date of the first registration until the 31st of December of the same year. So an example of that would be someone coming into the industry who registers with us, let's say in May, and wants to commence work from that date. So his Fidelity Fund certificate will be issued for that year, the remainder from the date on which he registers until the 31st of December of that year. The following year, yes.
Advocate, sorry, I see on the chat there's few people who are saying they cannot hear you. So I'm thinking if it's if you can give me thumbs up, colleagues, maybe if it's one issue, Jeanne, you would need to restart your machine. Are you able to hear Advocate Vile? Because we don't want to disadvantage you. Okay, looks like everyone, they can hear you. Sorry about that. Continue, Advocate. Those who can't hear her, please refresh your system. Thanks.
Thank you, Naledi. Okay, so we were just giving an example of the calendar FFCs, which are prescribed by the regulations. So what that means is the year that you begin operating as a property practitioner, the date on which you register is the first date of the first year that your FFC is valid for, and it will be valid for the following year and the year after that, and it will then expire on the 31st of December of the third year. Your first year then being the first date of registration that year or part of that year. So please remember, it's a calendar year in terms of the regulations. So if you register in May, your FFC doesn't expire the following May. It expires the end of December of the same year for that year. And because it's a 3-year FFC, it goes on for another 2 years after that. So I hope that is clear. Some important information, and there are quite a few slides here which you should perhaps take note of. Registration of property practitioners, same as with all the estate agent ones that we registered before, requires the registration of a firm and a director of that firm. And if you are not a director, you register as an employee of that firm, and it is required that a firm and the director of the firm register simultaneously. So let me go on and explain that a little more. Property practitioner firms and their directors register simultaneously, and I'll tell you how you do that. All persons who register and operate a firm are designated as directors. All other persons registered under the firm are designated as employees. The reason for this is that currently we have a specific education requirement for a principal, and a principal only operates as an estate agent. So principals currently, because of the nature of how they are defined, it applies only to estate agents. So you will not be called a principal or a full status agent or anything like that. That does not apply in any category of industries except your estate agent industry. So all other industries, you will register, the director or member will register as a director, and the sole proprietor similarly will register his firm as well as himself as the sole proprietor of that firm, and any employees will register as employees. Please note that a company's directors, as reflected in their documents, their company documents, must register as directors of the firm. In terms of the regulations and the Act, all directors, all members, as well as all trustees of a trust must hold a Fidelity Fund certificate, not simply the person who actually does the day-to-day operations. If there are non-executive directors, they can apply for exemptions, and we'll have a look at that in due course. So there you've got it, a company director, a CC director, and the trustees. And there is a proviso that's important, and this is the one I mentioned, which is Regulation 41.17. And this applies to directors, members, or trustees who fall within this specific category of the regulations. And Regulation 41.17 says, where a property practitioner that is a business property practitioner, and please note, a business property practitioner is a firm, has non-executive directors or has finance, marketing, IT or HR directors, or any other director who is not directly concerned with the management and oversight of individual property practitioners, exemption should ordinarily be granted from the provisions of Section 48(1)(b) and 48(2) in respect of such persons, upon application being made to the authority. So that directs us that where those kinds of directors apply for an exemption from holding a Fidelity Fund certificate, we should provide that exemption for them, as long as all the criteria that are set out in Section 4 have been met. I'm going to move on quickly to exemptions and the exemption provisions, which I've mentioned briefly before, and we'll look at in a little more detail. Section 4 permits exemptions to be granted for a maximum of 3 years. They also do not apply retrospectively. The address to be used for directing exemption applications is Section 4 exemptions at the ppra.org.za. Please note with a 4. Please do not direct exemptions at the ppra.org.za or use that email address for Section 4 exemptions, because those relate to equivalency exemptions, and those will go to the Education Department. It's a separate regulation, it's a separate process, and if your Section 4 application lands up there, the chances are that you will not hear anything further from them, because they do not deal with those. You also need to indicate from which section of the Act you seek exemption in your application. The process requires the submission of an E1 form, and you will find that form in the regulations. You'll also find it on our website, but it's to be found under Regulation 41.21, where the E1 form is specified and you have a template. That needs to be completed and signed. You can include a motivation in it, or you can add additional motivation where needed. It will then be submitted to the committee. The exemptions committee will consider it, and a certificate of exemption will be issued if your exemption application is compliant, and after consideration of all the different provisions that have to be considered by the exemptions committee, which are contained in Section 4. So that is the process for exemption from all provisions of the Act, if there is a need to apply for those. you will also see that I specify one particular type of exemption, and this is the trust account exemption. Now, you will be aware that all property practitioners, in terms of Section 54 of the Act, must hold a trust account in which they place all trust money which they receive and which has to remain in that trust account until such time as they are lawfully entitled to pay it out. Now, in terms of the Regulation 2, there is quite a lengthy process which we can follow in order to exempt property practitioners from holding a trust account if they qualify to do so. The major qualification for being exempted is that you do not receive, hold, or pay out any trust money of any kind. So if you have, for example, a state agent firm that does only sales and all your trust money goes directly to the conveyancing attorney, you do not hold deposits, you do not hold any kind of money or sale prices or anything else as trust money, and all that money is paid directly by your clients into the account of the conveyancer, then you can apply for an exemption from holding a trust account. You use an affidavit, which you will find a template for in Regulation 2. It's also on our website. And you can complete that affidavit, have it commissioned, please, not just signed. Please note that the difference between a statement and an affidavit is whether it is commissioned by a Commissioner of Oaths. The Commissioner of Oaths is an attorney. Banks have them ex officio. You also can get them from the police station, where you have someone who will commission your affidavit for you. It must be commissioned, otherwise we cannot consider it. And that must be sent to audit@thepra.org.za. Alternatively, you can include that affidavit with your application to register, and we will then forward it to the audit department. They will attend to the process and issue you with a notice to say that you have been successful in obtaining an exemption from holding a trust account, and we will then register you without a trust account. Something important you need to notice, ladies and gentlemen, is that deregistration, dormancy, ceasing to operate, selling a firm as a going concern, or resigning as a director all have very important consequences within the Property Practitioners Act, which you need to be aware of. A property practitioner who is the director of a firm is responsible for that firm, its compliance, and any trust money that it holds. As part of that director cannot simply resign as a director and then assume that he has resigned from his responsibilities in respect of that firm under the Property Practitioners Act, because that is not the case. In terms of Section 54(9), any person who wants to close or sell or deregister a firm or a business property practitioner must comply with the provisions contained in that section relating to the winding up of the trust account, the closure of the trust account, the submission to us of proof of all of those activities, a request to deregister the firm and himself where that is applicable, and only then will we be able to release that director from being associated with that firm, and he will be able to register under another firm or exit the industry or do whatever he wishes to in that regard. So a director who deregisters a firm under Section 54(9) will then be deregistered as a property practitioner, and his FFC will lapse. He may no longer operate in the industry unless he registers under a different firm, either as a director or an employee. So what's important is that everybody has to be associated with a firm and registered under that firm. And if that firm closes, then anyone who is associated with it, their FFC lapses. As soon as we deregister the firm, we deregister those persons as well. unless they are employed and hold an FFC under another entity, in which case that registration will continue to operate. There are the provisions of section 54(9) to 14, which require property practitioner business owners who cease to operate as such, or whose FFC has been withdrawn by us or has lapsed, or whose FFC has not been renewed by the PPRA, or who has been disqualified under section 50, must perform all of those activities. Wind up and close the trust account, pay out trust monies to the owners, deregister the firm with us to avoid FFC fees, penalties, and annual audit requirements and any fines associated with late compliance with that. No property practitioner may be issued with an FFC under any firm if he is a director or principal of another non-compliant firm. So if you're a principal, say, or a director, say, of 5 different property practitioner firms, and one of those firms is non-compliant, you will not be able to receive a Fidelity Fund certificate in relation to your other firms. And the reason for that is simply to ensure that any unscrupulous property practitioners who open a firm and meddle with the trust monies, fail to submit audit reports, to stop them from simply abandoning that firm, going on and opening another firm and obtaining a Fidelity Fund certificate under that firm. All natural persons pay FFC registration and renewal fees, and all firms are required to pay an administration fee on registration. All right, all employees who leave their employer must inform the authority in writing within 14 days of their change of employment and either register under another employer or they will be deregistered. And failure to do so does attract penalties, so please be aware of that. All property practitioners must advise the PPRA before the 31st of October of the previous year that they are leaving the industry, or they must renew their Fidelity Fund certificate before that date for the following year. So that's a very important criteria as far as renewal is concerned. The year in which your FFC expires, you are required before the 31st of October of that year to apply for and pay for your FFC for the following year by way of an FFC renewal. Alternatively, you must advise us before the 31st of October of that year that you are not going to be operating the following year. And when your FFC expires on the 31st of December, you will no longer be operating. This is important because if you don't tell us, then the Act says you must renew, and your failure to renew on time before the 31st of October will attract penalties, which you obviously don't want to do. We'll talk a little bit about fees, fines, and penalties here. Registration fees, FFC fees, and renewal fees are established by statute. They are in the regulations, and there's also a provision in the regulations which provides for a CPI increase every year in relation to that. Property practitioners also pay a statutory levy to the Property Practitioners Fidelity Fund when you first register. That was initially in 2022 an amount of 400 Rand. It escalates annually, and that is a once-off payment as the regulations are currently, and that once-off payment goes to the Fidelity Fund. Penalties for late or non-compliance are also established by statute, and statutory fees and penalties, as I've indicated, will escalate in terms of the Act. Fines for contraventions are also levied by inspectors. They use a compliance notice under section 24 to 26. So if you have an inspector come to your premises, or the inspector becomes aware of some sort of complaint against you and investigates it and finds that there is a contravention of some sort or some sort of non-compliance, they will issue you with a compliance notice, and that will require you to pay a fine as well as rectify the non-compliance. Major contraventions are dealt with by a disciplinary process, which includes notifications, requests for a response, the convening of a hearing before an adjudicator, and a sanction in the form of a reprimand, a fine, or in serious cases, the withdrawal of a Fidelity Fund certificate. Please remember that the authority to reduce, increase, or amend a fine rests only with the adjudicator in a disciplinary process. Contraventions or misconduct include non-compliance with the provisions of the Code of Conduct of the PPA, or the PPA. Please note, as far as the Code of Conduct is concerned, in terms of the regulations, it provides a generic Code of Conduct which existed previously and which we as the PPRA must amend, and in doing so, we must in fact provide a code of conduct for each industry. We do that in consultation with the industry. Many of your industries will have their own code of conduct, which is put together by their voluntary body. And obviously those codes of conduct will be of valuable assistance to us in deciding what the code of conduct for the various industries should contain. As far as the current code of conduct is concerned, if you have a look at it, and you'll find it in Regulation 34 of the regulations, you will note that there is a first portion of the code of conduct, which is a generic portion and applies to all property practitioners. After that, there is a section which deals only with estate agents. Obviously, that doesn't apply to you if you are not an estate agent, and your code of conduct is in the process of being drafted, and for each industry it will be drafted specifically, and that will be included as the regulatory code of conduct for that industry. Some contraventions, which include operating without a Fidelity Fund certificate, trust money irregularities, the display of a lapsed Fidelity Fund certificate, failing to return money which was earned while operating without an FFC, and using the PPR's name or logo without permission, are all criminal offences in terms of the Act. There are others. These are just a few of the main ones, but you will find as you read the Act that there are specific instances where the Act designates a contravention of that provision as a criminal offence. So please note that property practitioners now operate in a regulated industry. So it's essential that you're aware of the legislation that governs how you may operate and what you may do. And that is the Property Practitioners Act 22 of 2019 and the regulations published by the Minister under that Act. Please note that a schedule of fees payable for registration and other activities is to be found on the PPRA website. We'll move on then to the registration process. The director of a property practitioner firm is required to register a firm by submitting the following documents to the PPRA Licensing and Registrations Department, and you use that following email address. Business property practitioners' application form must be completed and signed by all the directors. That is the first document you will submit. Also, the company's or CC or trust documents or partner agreement, where that exists, showing the details of the directors, members, trustees, or partners. Also, a bank letter signed and stamped by the bank, confirming the details of a trust account held by the firm and stating that the account is held in terms of Section 54.1 or 54.2 of the Act. Now, as far as that is concerned, the Act requires that the bank designate that trust account as a trust account held in terms of Section 54.1 or 2 of Act 22 of 2019. A 54.1 trust account is a trust account which you hold, which all your trust money goes into, and it includes trust money which has to be paid out perhaps within the month, almost immediately, on transfer, etc. A 54.2 account is also a trust account, but it's investment trust account which you can open, which also has to be registered with us. You have to advise us of this and provide us with the bank letter. And that is one that you will put long-term deposits for example, rentals into, so that it attracts interest. You will also note, as we discussed earlier, that you either follow this process of submitting the bank letter and the requirements, or you submit a letter of exemption where you have been exempted from holding a trust account, which is issued by the PPRA. Alternatively, as indicated earlier, your application in the form of your affidavit, which applies for such exemption. Also, what is required here is your auditor's letter. That is a letter from your auditor confirming that he will be performing audit functions for the company or the CC, whatever it may be. You also need to submit a company resolution if there are 2 or more directors, as per your company documents, confirming who may act as the principal director of the firm. So that is, the principal there is used as the main director of the firm in order to operate the firm as a going concern and take responsibility for all its functions. Your BEE certificate is also required unless the firm is a sole proprietorship or a partnership. Section 50, sub A, sub Roman numeral 10, requires that no property practitioner may be issued with a Fidelity Fund certificate unless he is in possession of a BEE certificate. Now, we have had some discussion in relation to what that BEE certificate entails and what degree of compliance is required there. And after consultation with our senior counsel, as well as the ministry officials and the industry itself, the PPRA has advised that a BEE certificate is acceptable, which is valid as far as the person or the party or entity that issued it is concerned, and is also valid as far as being current, where your timelines are concerned, but your BEE certificate does not require in its content to indicate that you are BEE compliant. Okay. So in terms of the property charter codes, you are required to have a certain number of points based on your BEE status. If you are above a level 8, you are generally not compliant, and that will be indicated on your Fidelity Fund certificate. Sorry, I beg your pardon, on your BEE certificate. So as far as that is concerned, your BEE certificate must be submitted. It does not require to be a compliant one. And that applies only to juristic persons, as I've said there. So you're looking at your companies, CCs, trusts, who are required to submit that. A SARS tax clearance is also required with your application to register your firm. And this is for all firms, whether it's a juristic person or a sole proprietorship or a partnership, every firm must submit their SARS tax clearance. And then you will need to make payment of the administration fee for the firm and provide us with proof that that has been done. As I've indicated, directors must also register themselves individually, and they will submit all documents to the same email address along with their firm application. This will be their ID document, obviously a copy, your individual property practitioner application form, completed and signed, your E1 form applying for an exemption from Section 33, and that relates to an education requirement. Let me explain briefly what the situation is as far as education is concerned currently. You will be aware that the existing regulation under the old Act, which remains in force currently, for estate agents provides the NQF and PDE and practical training qualifications, which an estate agent has to have in order to be a full status or a principal estate agent. Now, the new regulation 33 provides that we must, in fact, set up and decide on the required standard of training for each industry. We must also provide and ensure that property practitioners complete a practical training course of at least 6 months, and that you write your board exam, which is your professional designation exam or PDE, before you can operate in the industry. Now, currently, the PPRA cannot provide a standard of training that is needed for all the different industries. They are in the process of deciding for each industry through the education department, and after consultation, what requirements will apply for education standards of training. The PPRA is also not currently in a position to allow you to complete a registered or accredited practical training course and a PD exam, your professional designation exam. These are not yet finalized for each industry. So what that means is you do not need at this stage to comply with any education qualifications in order to register and operate. And that's because there aren't any at this stage. In terms of the regulation, however, you do at least have to have a practical training course as well as have written your PD exam. Now, obviously, those are not yet available, so we cannot provide you with that. And as a result, you need to apply for exemption from those two provisions so that you can operate, because of the fact that the Property Practitioners Act regulations specify that those are needed. So that is why you will need an E1 form. As I've explained before, your E1 form is an exemption application. And in your E1 form of this nature, which you're going to include in your application, you're simply going to say, request an exemption from Regulation 33 education requirements for us to operate as required by the Act. And the reason is that we are not yet able to provide you with the training facility or a PDE exam for you to pass at this stage. Proof of payment of your registration fee is required. That's your registration and Fidelity Fund certificate fee. Employees must also submit their individual application form. The individual property practitioner's application form completed and signed is needed. Your E1 form, as I've explained, a letter of employment signed by the director and the employee and stating the reference number of the director or the firm must be submitted to us. Where you have not yet received that information, you may put into the letter of employment the name and ID number of the director, as well as the registered name of the firm instead of the reference number. Proof of payment of the registration fee is also required, and as set out earlier, all of that gets sent to manual registrations at the PPRA. Relating to fees for provisions such as employment changes, name changes, etc., registration of a firm is free as far as your Fidelity Fund cost is concerned. You simply pay an administration fee to us, which is specified on our website. All other registrations and activities, see your schedule of fees. Some of them attach a fee, some of them attach a administration cost. Your employment change is free unless you have been deregistered, and this is important to note. So if you are not linked under an employer, as I said earlier, you cannot operate and you must be deregistered. So when we get an instruction or advice from you or from your previous employer to say that you are no longer employed by them, you must immediately be deregistered in terms of the legislation. If, however, you advise us prior to being deregistered that you are moving from this firm to another firm and you request that you be registered under that new firm and the employment simply be transferred across, and you do that before the deregistration, then we will do that free of charge, say for a registration, an administration fee. You will not need to pay for a re-registration. If, however, you have already been deregistered, so if you tell us that you're leaving and next month you come back and say, right, I've now got another job and I'm working for a different property practitioner, you will then be required to re-register. And please note, all employment changes also require your ID document. Just before we finish, we're going to stop quickly at auditors. I mentioned to you that you needed an auditor's letter to be able to register your firm. All registered directors, please have a look at the audit manual that is on the website. The winding up of trust accounts, the registration of trust accounts, the audit of your accounts, your trust account, and your business accounts are all set out on the Act in a very, very good manual that was prepared by our audit manager, Thomas Makupu, and you will find all the information that you need there. As far as the audit requirements are concerned, the one thing you need to be aware of is that if you have a trust account and you have not been exempted from it, you must submit your trust account audit completed by your auditor, which he does via the audit portal, or alternatively directly to the audit department where the portal has a problem, which it does at the moment. We hope to have it up soon. But generally, he will do it via the audit portal using your firm registration number. And that will go to the audit department. They will check the audit report. If they are satisfied, they will accept it. If not, they will ask for further information. Let's just go back for a moment. In terms of that requirement, that audit report must reach us within 6 months of your financial year end, or it will attract penalties. Very important here is that if you don't submit your audit report and you are up to 3 months late, you will be charged a daily penalty for that. Once you are 3 months late for your audit report, it is considered to be a non-submission, and the fine for non-submission is 25,000 Rand. So please do take that seriously and ensure that you instruct your auditor in good time to submit your audit report and provide them with the required information. Please note that in terms of the Act, it is your responsibility to ensure that your audit comes in on time and correctly, and not your auditors. Your contract with your auditor is outside the jurisdiction of the PPRA. We don't regulate that contract. But if your auditor fails to do what he should do in terms of your agreement, you remain the person who is accountable. So as you know, you cannot delegate accountability. So that's how it applies. The other thing you need to know is that also in terms of the Act, you are required to audit your business accounts annually within 6 months of your financial year end. But those audits, those business account audits or financial statements, they're generally known as audited financial statements, do not need to be submitted to us. Those you keep, and if an inspector comes along, he will probably ask to see them and you will be able to furnish them. You also need to be aware that there is an exemption in terms of Section 23 of the Act, where anybody who does not have a trust account and whose turnover is less than 2.5 million per annum may have their business accounts prepared and reviewed by an accountant, and don't need to use an auditor. That's in order to save you costs. But that, bear in mind, is only if you don't have a trust account, because your trust account can only be audited by an auditor and must be audited by an auditor, and if your turnover is below 2.5 million per annum. There is the provision which I was mentioning, the Section 23 provision, and it sets it out for you quite clearly there. That brings us to the end of the webinar. If there are any questions, please put them on the chat and the lady will assist you, or raise your hands and Naledi will assist you as well, and we'll try and answer all your questions. Thank you very much for attending.
Thank you so much, Advocate, for that presentation. I do have a few questions from the chat before we go to the hands. Let me go to the first one. And I see my email here on this last slide is incorrect. I will just send it on the chat. It's naledi.mpatlele. Advocate, the first question from Renee, how do we pay without a 7-PIN number?
All right, when you submit to manual registrations, if you don't have the bank account details, you will receive an instruction from the manual registrations administrator advising you of the bank account, and you pay using your 13-digit ID number. Or if you are not a South African citizen, but you have a valid work permit, you will use your passport number as well as your name.
Okay, thank you. I have another one from Pauline. Good morning. On slide 6, which speaks to property facilitator and intermediaries, would this extend to persons who merely pass on a prospective customer's name and contact details to a financial institution to assist a prospective customer with a finance application for a property transaction?
That sounds like you're talking about a bond originator, because that's the one that deals with finance. Anybody who arranges finance must register as a property practitioner if you are somebody who assists in obtaining finance. So I don't understand why you would be passing on someone's name to a financial institution. They would normally be doing it themselves. If you're doing it in a representative capacity on behalf of somebody else, in order to assist them get financing for a property, then you are definitely operating as a bond originator or finance originator, and you would have to register with us.
Okay, thank you. I have one from Ferdi. What if a practitioner operates as a sole proprietor?
Yes, I did deal with that in the slides. What is the question about a sole proprietor?
I will allow him maybe to elaborate. I think maybe it's an incomplete question because he said, what about soul? So I think maybe he sent that question when you were on that slide. I will give him a chance if he wants to pose it correctly. And Nhlanhla, because you were talking about that you are building residential units and rental, in your own capacity, you would not need to register because those are your properties. But once you start assisting other people, you will need to register. And if you are trying to get...
Sorry,
yes,
carry on. Are you
no,
finished?
Nhlanhla, there's a comment on the chat. Nhlanhla was saying, I want to build with, she has profit that she wants to build units and she wants to sell them.
Then you are a property developer. It doesn't matter if it's your own. If in terms of the definition, if you do it in the ordinary course of business, in other words, it's your business, and it is registered in the name of a company or a juristic person, then you become a developer. And if you sell those units yourself or market them yourself, then you fall into the category of a property practitioner and you must register with us. So what's important for you to note is that even if you sell your own property as a property developer, you fall within the jurisdiction of the PPA. The only time you don't is if you are, as an individual, you own properties in your own personal name and you do not do it in the ordinary course of business. In other words, it's not your business, it's something that you do as a sideline. That's the only time that you don't have to register for us. Otherwise, you are a property developer and you have to register with us.
Okay, thank you for that, Advocate. Sibongiseni, he's asking, how long does it take to reserve an agency or a firm name?
It's usually about 5 days. It depends on how our system is. If our system is down, which it is at the moment, it has been for the last 2 days, much to everyone's disgust, and not least of all ours, because we cannot work. It will take longer, but generally that's what you will need. And if you can either do it on the portal, or you can, if the portal is open, which as I say, at the moment it isn't. Otherwise, you just send it to manual registrations at the ppra.org.za, the same address, and say, I would like to reserve a name, and they will assist you with that. You should get it within a few days. The reason why that has to be done is because the legislation specifically states that we may not issue an FFC to any firm that operates using a name, a trading name, that is the same or confusingly similar to another name that is operated, that is registered with us, and that operates a property practitioner. So we have to ensure that that is complied.
Okay, before I go to the hands, let me take the last one on the chat from Samantha. Hi, Deborah. Please advise, does an estate agency require a signed letter from the PPRA exempting them from the trust account if they registered the agency with a trust account exemption?
The trust account exemption is your signed letter. So in other words, you will have got an exemption certificate from the board, from the audit department, to confirm that you were exempted. If you didn't do so, we would either not have exempted you, or we would have exempted you on the basis of the fact that that was sent to us. So if you didn't get your exemption confirmation from audit, please consult them, audit at the ppra.org.za, and they will send you your confirmation. If you applied for your exemption from the trust account at the same time that you applied for the registration, and you've got your registration and your FFC, then you can assume that that was granted. But you should still get a certificate from the audit department. So if you didn't, then just contact them and they'll be able to send it to you.
Okay, thank you, Advocate. Colleagues, I gave you access to the microphone. Let's go to the hands. Marie is the first hand on number 1. Please unmute and ask your question. Can you hear me? Okay, I will come back to you because I'm looking at the time. Crystal, please ask your question. I'll go back to Maria after you. Okay, maybe they're still sorting out their microphones. Let's try Shedris. Please unmute. Colleagues, can you hear us? Can you hear Advocate? Can you hear me?
Yes, we can, Naledi.
Oh, okay.
Yes,
okay, no, thank you so much. Then let's go back to Crystal. Please ask your question.
Can you hear me?
Yes, Crystal, you can ask your question.
Hi. For auctioneers with a trust account in section 54.1, do you still need to be audited if the income is still under a 2.5 annum?
Yes. If you have
Thank
a trust account, it must be audited.
Thank you. And even if it's a new company, there is no funds, nothing happening yet. So you still need to apply, get an auditor letter.
Yes, you do.
Thank you.
It's two different things. You're going to get your letter from your auditor confirming that he is the auditor for the firm, and you'll do that and submit it when you register your firm. At the end of your first 12 months, at the end of your financial year, so let's say you register in August and your financial year end is February. When you register, you're going to submit us your letter from your auditor saying that he is the auditor for the company. Then,
Thank you.
At the end of February, you will require that same auditor to provide you with a trust account audit report, and you will submit that audit report to us within 6 months. So that means by the end of August. And that would cover that period up until the end of February when your financial year ended. And you would then submit it to us. We would go through it, and our audit department will then accept it, and you would then continue to act. As far as your business accounts are concerned, you also have to audit them if your turnover is over 2.5 million. If your business account is lower than 2.5 million, you can get it reviewed by way of an accountant. But your trust account always has to be audited by an auditor.
Thank you so much. Let's go back to Marie. Please unmute. Okay, Cherise. Okay, let's move. Susan, please unmute Susan.
She's spoken to somebody because she is now applying.
I want to know, how does one apply for the BEE certificate? Where do you go to?
And that's what she is.
There are accredited BEE. Can we have somebody mute, please? Whoever's talking. And
honestly,
The sound is coming from the question. Okay, he muted. I think he is.
Okay, thank you. Sorry, I just couldn't hear very well. Okay, so a BEE certificate is obtainable from any accredited BEE authority, and usually it is auditors. There are a number of auditors who are accredited to give you a BEE certificate. There are also a lot of entities that are accredited. You can Google them, you'll find lots of them. There are some that you can get from SIPC, I believe. They issue you with a statement based on the information you give them under certain circumstances. I know they are expensive. They're not cheap to get, but you have to go to an accredited agency to obtain it.
Okay, thank you so much. Then there's Professor Kunene.
Good, how are you, Advocate? I'm sorry to send an unclear message. I wanted to check. I'm a sole proprietor and I'm a developer. So I didn't get you very clearly when you said I needed to register the enterprise and myself as a director.
Yes.
I'm following the presentation. As my first question, that's why I said I needed you to clear it up to be more clearer. What is the process of a sole proprietor? And one more question. It talks to now the fidelity, so the trust account. Do I have to go to a bank and ask them to open the trust account for me, or what is the process? Thank you, ma'am.
Okay. All right. I think it will be helpful if we provide you all with a copy of the presentation, because there will be information contained in there. But briefly, to register a sole proprietor, you're going to register as the sole proprietor of that firm, and you will designate yourself as a director when you submit the application form. You register your firm separately, and you indicate that it's a sole proprietor on the application form. You register yourself separately as the director of that firm. Even though you are in fact a sole proprietor, you will find a place on the application form where you can register yourself as the designated director of that firm, but it will ask you what kind of firm it is, and you'll be able to put in all the details. So exactly the same thing applies. You will do the two registration forms that you will do for the firm as well as for yourself as an individual, and you will submit those documents which I've set out in the application in the webinar slides. As far as a trust account is concerned, every property practitioner, in terms of the Property Practitioners Act, must have and hold a trust account, must keep it open, must place all trust money that that practitioner receives into that trust account and keep it there until he is lawfully entitled to pay it out. The exemption happens where you do not receive trust money of any kind, but it's not an automatic exemption. It must be applied for. And you will do that by applying using the E1 form, saying to the exemptions department, I have completed the form. It applies to me. I do not receive trust money. I won't receive trust money. If I had a trust account before, I've wound it up and I've properly closed it down and submitted audit reports for it. Here is proof. And if I need to accept trust money at any time, I will advise the board at least 60 days beforehand of my new trust account in order to allow me to do so. And that is the process in relation to your trust account. So you must get your letter from the bank in which they say that the firm entity has a trust account in its name, which is registered in terms of Section 54(1) of Act 22 of 2019, and that must be submitted to us along with your registration application.
Okay, thank you so
Thank
much.
you very much.
Okay, let's go to the second person. Happy, please unmute.
Hi, Naledi. Hi, advocate.
Morning.
My question is on the education, that slide of education, advocate.
Yes.
Previously, we were told that after acquiring our NQF5, of which I just did, we
Yes.
need to do the 2 years practical before writing the PDE5. Now, I had a meeting with my principal, my current principal, that he should mentor me. One, he asked me what is it he's going to get from the PPRA in terms of payment for mentoring me. And then two, I want to know that does it still apply, that compulsory practical? Thank you.
Okay, thank you. Let me explain briefly. I'm not an education specialist. The education department is a separate department, but I will advise you what I am aware of and see if that answers your question. The way you become a property practitioner under the estate agency industry is to do, first of all, a candidacy, which was previously 12 months. It can now be done in 6 months. So you register with us as a candidate property practitioner or estate agent. You get your Fidelity Fund certificate as a candidate. You do your practical training with your mentor, who you find to mentor you, and it's usually the principal or the estate agent at the firm where you are employed, because they are responsible for you and for your compliance during the time that you are a candidate in terms of Regulation 33. When you have completed that, you can sit for your PDE exam. Your first PDE exam is your junior board exam, which is what we call your PDE4. You can only write that once you've got your initial NQF qualification, which is your NQF4 qualification. So and that's your qualification in real estate. Alternatively, if you have some other kind of education qualification, which is relevant to the property practitioner industry, you can apply for what we call an equivalency exemption. Now, please, everybody, do not get confused with your Section 4 E1 form or trust account affidavit exemption application and this one. They are two completely different things. Your equivalency exemption is an exemption that you apply to the education department for, and you say, I have an LLB degree in which I have property law modules, and please will you give me an equivalency exemption because my LLB is at a NQF 8 or whatever it is, and you only want an NQF 4, so please can I have exemption from that against the NQF 4 qualification? And the education department will look at it and more than likely say, yes, that's fine. And they will exempt you from having to do your NQF4. They might even exempt you from having to do your NQF5. But once you have either got your NQF4 or your NQF4 exemption, and you've done your candidacy, which is those initial 6 or 12 months, depending which one you applied for, you can then write your professional designation exam level 4. After you have done that, you can then go on and complete your NQF5 or obtain an exemption from your NQF5, and you can write your PDE5. Now, currently, when you complete your NQF5, you are able to register a firm. You can register yourself as an estate agent principal, and you then have 2 years in which to write your PDE5 exam. Okay, it's not a mentorship. Nobody has to mentor you. It's simply a 2 years experience that you can get running your own business before you write the PDE exam. Now, I am advised that that is about to change, and the education department is going to require you to have your PDE5 exam before you register as a principal of a firm, before you can register your firm. That is not yet the case. And when that will come in, I'm not 100% sure. So at the moment, you have to have written your NQF5 and you can then register your firm and you can register as a principal and you have 2 years in which to write your PDE5 examination. So that is the process, but your 2 years is not a mentorship. You will already have done your candidacy. And this applies only to estate agents, everybody. Please, it doesn't apply to the other entities. Now, the other entities, as I explained, because the PPRA doesn't yet have standards of training for your industry, you can join as a director of a firm, you can register your own firm, or you can join as an employee without any qualifications. You do, however, in order to operate as a property practitioner, have to have had a 6-month accredited training course that you've done, and you have to have passed a board exam. Now, because we don't have that available yet for your industry, you have to apply for exemption from that provision of the regulation. Otherwise, you're in contravention of it, and we're not allowed to give you an FFC. So that's why you simply, with your application form, put in your E1 exemption form saying, please, can I be exempted from the education requirement of the PDE and the practical training, because the PPRA can't yet provide me with that service, and I want to practice in the interim. And that is for the rest of the property practitioner industries. I hope that's clear.
Thank you, Advocate. Okay, Motsepe, you're sorted with that. Let me move to Samantha. Please unmute and ask.
Morning, Deborah. Morning, Naledi. Thank you for the
Morning.
informative webinar. I just wanted to double check with you with regards to trust account closure. So if the agency has registered with a trust account, they now have realized they want to do a trust account exemption. Am I correct in saying that all is required is a wind-up report from the auditors and a letter from the bank stating the closure of the trust account? That is my first question. And the second question is, can this be uploaded to the PPRA portal at any time, and who completes this?
All right. Yes, absolutely. You do need to have exactly those, as you said, your winding up report from your auditor. When our portal is functioning, which it should be most of the time, but currently is not due to an email migration issue, that will be submitted via the auditor's portal on our website, and it will come to our audit department. Our audit department will accept it, and that will resolve the issue as far as the audit, winding up audit of your trust account is concerned. We will require a letter from the bank specifying the number of the trust account and confirming the date on which the trust account is closed. This is important because the winding up report has to cover the period from your last audit up until the date that the trust account is closed. So we need that. Once we receive that, the only other thing we need is we need a letter from you saying, I wish to deregister the firm, or I don't want to deregister the firm, but I want to get an exemption from holding a trust account. And then your exemption application form, your E1, your affidavit rather, for an exemption will have to accompany that letter to us at the registrations department.
Okay, perfect, Deborah. Thank you for that. So first the auditor completes it, does the winding up report, and then furthermore, the principal of the agency follows up with the auditing department or the registrations department?
Okay, as far as the audit is concerned, you can follow up with the audit department to confirm that they've received your audit.
Okay.
Your winding up audit. And at the same time, you can submit to them your application for an exemption from holding a trust account.
Perfect.
And if
Thank you very much, Deborah.
They will tell you if there's a problem. If they say we haven't got your winding up report yet, they will tell you, or if they say yes, we've got it, they say thank you, we will have a look and we'll let you know whether you are exempt.
Perfect. Thank you very much for that.
Thank you, Samantha. Motsepe, sorry, I just want to double check. Were you started with a question or you have follow up?
No, in terms of the explanation, I'm settled. The
Okay.
only, yeah, if maybe you can allow me to ask about the trust account. If I am registering a company now today, because I don't even know how much I'm going to do, is it compulsory to have a trust account now or the normal account, business account?
You must have a trust account now, otherwise we will not register you.
Okay, noted. Thank you.
Thank you. Let's go to Kumesh. Kumeshan. Sorry if I'm butchering your name. Please unmute and ask the question.
Good morning, Deborah and Naledi. Thank you.
morning.
Much appreciated for the informative presentation. It actually clarified a lot of information that I personally needed a bit more clarity on. I just have one question regarding the trust account, right? I see there was a few questions on the trust account, which obviously clarified a bit, but there's one more question that I just want to raise regarding the trust account. So basically, at the initial stage of opening up a real estate company in terms of obviously our registration. If the company is not going to be holding trust funds in terms of obviously potential purchases, deposits and actual trust funds, do we actually need to have a trust account active at the very outset of registrating a company?
Okay, the answer to that is yes, you do. You have to submit when you register either proof of your trust account that has been opened. Alternatively, you have to apply for an exemption from a trust account.
Okay.
The exemption application is the E1 form, and you have to, no, sorry, not the E1 form, the affidavit. And the affidavit, in it, you swear that you will not be receiving trust monies of any kind. That is deposits for a sale, deposits for a rental, rent that you're paying over to a landlord, any of those things. Those are all trust money, okay? Any money which you receive, which has to be paid to somebody else and is not your money, is trust money.
Sure,
So if you're going to swear that you are not receiving any of those and you submit the affidavit with your application form, then you will get an exemption from holding a trust account, and we will register you on the basis of that exemption without a trust account. If you don't get that application in and we don't give you that exemption, you must have a trust account.
So with regards to rental payments, if we're obviously managing rental stock, right? Every fund that's paid at the end of the month in terms of rental from tenants, that's basically trust funds. So
Yes,
if
that's
we're
right.
receiving that, we'll have to have a trust account.
Absolutely.
Okay, excellent. That actually clarifies that. So in actual essence, every new company or obviously existing company should have a trust account just to obviously streamline what funds are coming in.
If they are taking trust money, they have to have a trust account. Otherwise, they must have an exemption. But we will not register you without one or the other.
Okay, excellent. Then in terms of obviously, just one more question, with regards to obviously recruiting agents, right? So every agent that comes in, the principal and the company would register them as a candidate attorney, so candidate property practitioner. Sorry. So with regards to qualifications, what sort of time frame do they have as a candidate before obviously they have to be compliant with the educational requirements of PPRA?
They currently have 2 years.
2 years, and then
yes, you cannot
then
be
they
a
have
candidate for longer than 2 years.
Okay, thank you, much appreciated for that, and thanks once again for the informative presentation. Thank you, Naledi.
Okay,
Thank you,
thank
Deborah.
you so much.
Thank you.
Let me take another question before I go back to the chat, then I'll come back to the hands. And I know with the flow of questions, there's a lot of interest on trust account. I think what I'll do, I'll organize another webinar with our audit department so they can come and explain auditing process, the format, their guidelines, and how to file and the timelines. Let me take a question from Duane. Please unmute. Okay, I'll come back to you. Let's go to Pauline. Pauline, please unmute.
Thank you, Naledi, and thank you, Deborah, for an informative session. I'm not too sure, sorry, I did drop off for a bit. I'm not too sure whether my question in the chat has been answered already, and if so, I'm happy to go back on the recording to listen in. If not, I'm just going to repeat the question that I've got in on the chat so you guys can let me know. That section that deals with the registration of the industries and specifically sections that relates to the property facilitators and intermediaries. The question that I have is really, does that extend to persons who pass on information of a prospective customer to a financial institution to enable that financial institution to assist the customer with a loan application? So almost as similar to an originator, but in a very basic sense, in that only information of a prospective customer is sent through to the bank, but that person, as a lead referrer, is then paid a commission by the financial institution, for argument's sake, for the forwarding of that customer's details for a loan to be entered into.
Okay, the question was replied. Yeah, I don't know, Advocate, do you want to take it?
Okay, I'll just to recap. That is exactly what a bond originator or finance house intermediary does, and you have to register with us.
Thank you.
Thank you. Matabo. Matabo, please unmute. Yes, we can hear you.
Okay. Thank you, Naledi and Advocate. My question is around the trust account. Say I'm running an agency and then I decide to use another service provider in terms of rental management, and then they offer to open the trust account for my company. So meaning that my original trust account that I opened when I opened the agency no longer receives funds. Can I be exempted and use the trust account of the service provider?
Only if the service provider is registered with us as a payment processing agent, like PayProp. They have to register with us as a payment processing agent. You can use them then. You can close your trust account and advise us that you are now using this particular payment processing agent, and the audit department will make a note of that and exempt you from holding a trust account.
Okay. And then my follow-up question is that, do I need now to register them under my trust account?
Register who, sorry?
Let's say I'm using PayProp and they have opened a trust account on my behalf. Do I need now to link the trust account number that they have opened for me?
You have to advise us. You have to send it to us with the details and your affidavit saying that you now use PayProp and you're not using your trust account anymore. And PayProp is a registered payment processing agent. It's all catered for in the affidavit, and you send it to us, and you've advised the audit department that PayProp is now your trust account holder, and you give them the details of the trust account with PayProp.
Thank you.
Thank you. I see you raised your hand again, Duane. Did you want to add another question?
Yes, please. Hi, Deborah and Naledi. I just want to find out, we are registered as estate agents. We offer both estate agency and managing agency activities. Do we have to register another company, or do we just have to apply for a FFC as a managing agent? Can we do it under one entity?
Yes, you can do it under one company. You can register the same company as an estate agent and register it again as a managing agent or whatever other industry you are operating in. And if you are operating the same company in 3 different industries, or you're operating 3 different companies in 3 different industries, You register them in each of those industries, and you get a Fidelity Fund certificate for each industry, and that's because the Act specifically requires that.
Thank you so much.
Okay, thank you, Advocate. Let me go back to the chats. I have Kim. What is the turnaround time for the manual registrations? And provided we've submitted the request, are we covered for being compliant? I think she's saying if all documents are compliant, what would be the turnaround time?
Okay, if all documents are compliant, we have 30 days to issue your Fidelity Fund certificate in terms of the regulations. If you don't get it, then you escalate it to me if you don't get assistance within the 30 days, or to whoever is designated to assist for escalated matters. But as long as your application is in and it's compliant, then we will not take any action against you in relation to the the Fidelity Fund taking longer than is required. But do remember that you are required to have a Fidelity Fund certificate in order to operate. So you need to apply for your Fidelity Fund certificate in good time so that there's not a delay. Because if it comes to a question either of enforcement or of the right to commission or anything like that, the dates will be looked at, and the proof as to when it was submitted, when it was attended to by us, etc., will be taken into account.
Okay, thank you so much for that. I have a question. I have a hand. Erna, please unmute and ask.
Good morning. Yes, I would just like to know, we did apply for 2 FFCs in March, and we've been trying to escalate it and make it, inquire on the website, and we are just not getting any feedback. So who can we address the matter to, please?
Okay, what industry were you in?
Estate agents.
Okay, so you did it on the website.
Yes, yeah. So we obviously we went to register the 2 candidate agents,
yes.
And yeah, we paid, we filled in the forms, we submitted it, but yeah, there's just no feedback. We tried to track the query, but it's
Okay, I apologize for that. Let me give you an email address that you can direct the escalation to.
Okay.
You can send it to, in fact, we can put it down in the chat, Naledi, if we can, but if you want to write it down, it's Nthebele, NTHEBELE dot Mahoa, MAHOA, at theppra.org.za.
Let me put it on the chat for you.
Thank you. Thank you so much.
Okay, I just pasted it. You will find it there. Is that all? Let me see on the chat if we have more questions so that. Okay, Dennis, when is the deadline for registration as a property practitioner for the new industries? When will the PPs look at the starting enforcement action? When will the PP look at starting enforcement actions?
Okay,
I'm not sure.
Yeah, in other words, he's saying how long are we giving them to register basically before we start enforcement? You're required to register now. Registration is open for it, and the Act says that you have to have a Fidelity Fund certificate in order to operate. Obviously, it's taking us some time to get used to the system. There are always glitches, there are always issues involved. Obviously we are having to onboard extra staff. It's 9 extra industries. It's taking us a while, and we're having some teething problems. So we are aware of the fact that there are large numbers of these applications as well as exemptions, etc., which have to be dealt with, and we're dealing with them as fast as we can. The fact that we have a system downtime for the last 2 days, and this is the 3rd day, makes it impossible for us to say to you, we can comply with getting those FFCs out immediately, because it means that we are literally hamstrung by the fact that we don't have a system that works. And they are working on it, and as soon as they're back, we get back onto the system and we get things going again. So what we are doing is, obviously it's taking us a bit of time. We are not specifying how long, but we are aware of the fact that people are applying and that we are getting them out as fast as possible, but there may be some delays. So we are not doing enforcement yet as far as that's concerned. And it's likely that we will put a time or a date on the website and say, all right, everybody, we now are where we want to be. We believe we've got no more backlog. We are dealing with matters as they come in, and you've had plenty of time now to apply. So this date is you can expect commencement of enforcement. Bear in mind, however, that is a fluid situation. It changes from time to time. It depends on a number of things, because we are busy trying to implement this act, which is very different from the previous one. Our capacity has also got to be adjusted and adapted, and that's what we've been doing in the interim. So if there is anybody who is not registered, but there is a complaint, for example, in relation to theft of trust accounts or something serious of that nature, or some sort of unethical activity, the Act says that we do have jurisdiction over you, even if you are not registered with us. So you will still get some sort of enforcement process, and you will then still be required to go before an adjudicator if appropriate. But as far as getting and obtaining your FFC is concerned, as long as you've applied, we are not taking action against anyone who's not yet got their FFC at the current moment.
Okay, thank you, Advocate. I think also myself, it gave me clarity as well. Thank you for that. Dennis, I don't know, I see you raised your hand. You want to add on what Advocate is saying? Dennis, because the question was coming from Dennis. I see he raised his hand. Maybe he can't hear me. Ke a leboga. Please unmute yourself. I'll go back to Dennis after you.
Okay, hi guys.
Hello.
So I was about like what do you call this? Like for someone being a candidate property practitioner to going from using the new system and the old system, like how they overlap, because there's someone who registered sort of last year before the whole system changed and was supposed to do their logbook maybe around November, and the system changed in July. So I wanted to ask, like, what system do they fall under? Do they fall under the old system or the new system when they were supposed to, like, their 12 months ending in November?
I need to check with Education Department. Naledi, perhaps you can give him NOMSA or Darky's email address, and then he can follow up with education. I'm sorry, I'm not able to assist you with that because I'm not sure. I don't have the information about your case, and I don't know how they apply it.
Okay, no problem.
Okay, ke a leboga. I'll put Mfundo Daki's, the Executive Education's email on the chat. He did do webinars, I think 3 of them on the 1st of July, before 1st of July, to explain on the processes of logbook coming to an end. But I will send you his email address. Are you sorted? Can I go to Dennis?
Yes.
Dennis? Going once, going twice. Let me go back to the chat and take a question, Advocate, before we can close. Okay, I have one from Mushwana. Do you accept BE certificates from Treasury website?
Yes, if it's a valid BE certificate for purposes of time and everything else, yes, no problem.
Okay, let me go to another question. I think we responded most of them. There's one from, okay, Crystal, we did take this one. There's one from Gary. Thanks for the presentation. In terms of directors selling 100% shares of their company or FM, please advise where I can find details of the requirements they must comply with as mentioned in terms of section 54.9.
Those are requirements in the Act, section 54.9. You need to read section 54 in its entirety and apply it. You also, if you want assistance in that regard, go to the website and look at our audit reference guide. or a reference manual, which has been put on the website by our audit manager, Thomas Makupu, and it explains everything in relation to how you have to comply with it.
Thank you. I have a hand from Natalie. Please unmute and ask the question.
Thank you. Can you hear me?
Yes.
Hi, yes. Okay, you've mentioned that with regards to registering more than 2 industries under one company registration number, for example, an estate agency and a managing agency. How does it then work with regards to, do they share a trust account? Do you open up separate trust accounts for each industry, registering them for FIC? I know you didn't mention that either as one of the requirements, but I assume that's still required for you to register your entity with FIC. If you are sharing the same registration number, will the managing agency and the estate agency have the same FIC number?
Okay, as far as the trust account is concerned, you can use the same trust account, and you just have to register it under the industry, under the firm, in each instance to make sure that there is a trust account that's open, and the audit has to deal with it for purposes of both industries. As far as the FIC is concerned, we are no longer FIC regulators for anybody who is not an estate agent, and in fact, the FIC Act specifically refers to estate agents, so we don't require FIC documentation for anybody from anybody except estate agents. Even with estate agents, we are no longer a regulator, but as I understand it, you still need to comply under the FIC requirements. So it still applies to your industry, but we are no longer a regulator for purposes of FIC.
Okay, and then so basically you can have a candidate being both an estate agent, have an estate agent FFC, as well as an employee managing agency FFC, correct?
Yes, correct.
Okay, thank you.
Okay, Advocate. I see Christel, she's asking a question which you touched on the slides regarding a turnover of 2.5 million, but in this case, she's asking for auctioneers. For auctioneers with a trust account, do you still need to be audited if income is under 2.5 for auctioneers?
Yes, you do. As soon as you have a trust account, you must be audited.
Okay, no, thank you so much. And then let me see, what is the definition? This one is from Trevor. This is the last question, Advocate. What is the definition of an intermediary in terms of the Act/regulations? Please advise what such a person does in terms of the PPRA guideline.
Okay, there is no definition in the Act of what an intermediary is. Intermediary is included in the definition of a property practitioner under Section 1 of the Act, and it doesn't state what such a person does. As far as an intermediary is concerned, in order to qualify as performing property practitioner activities, he would have to perform some sort of property practitioner activity as indicated in the Act. So an intermediary, if you look at the definition in Section 1, you will have a look and you will see that it tells you that an intermediary would have to include, although this is not a definition, it would have to include somebody who deals with, assists with, acts as an intermediary for the transfer or transaction which relates to property purchase, sale, lease, etc. And bear in mind that not only immovable property is included here, but included in the definition is a business operation or a business franchise. So that's basically the information that you have in relation to what you do. So if you do anything which deals with the transaction, transfer by way of some sort of a legal transaction of property, immovable property, or business processes, and your transactions involve any right, title, or interest in a property, as defined in the Act and regulations and the immovable property, you would fall within that category.
Okay, no, thank you. I see there's last 2 property practitioners who sent questions on the chat. Maybe let me take them, Advocate, before we close.
Yes.
Colleagues, you can also raise your hands so that we can engage. Cherise, do conveyancers check which category an FFC is allocated to? As a possibility of bond originators selling properties cannot be ignored. Was there an answer to this question? I don't remember we raised it.
No, it wasn't raised. Yes, your conveyancer has to ensure that you have a property, a Fidelity Fund certificate in the industry in which you are operating before he hands out commission.
Okay, so Megan, she says, can an agent that has an attorney-employee FFC still show and sell properties with that FFC?
No, absolutely not.
Okay, thank you so much. Colleagues, we really appreciate you for joining the webinar. On a Friday, these sessions are important, especially, with the new categories. You are still finding your way. I mean, even ourselves, me as stakeholder, I'm still learning from Advocate on what are the processes going forward, and we do appreciate them. And I think what we've taken from it, especially on issues of exemptions, if you want to apply for exemptions, you saw the email section 4, because I know they can be confusing. The one for education exemptions that you want to apply for, it will just say exemption, it's for equivalency for qualification. And the exemptions from trust account, it will start with audit, that email address. And also, the registration for the firm, we saw that is free from the presentation that Advocate gave us. And anyone who has a turnover of less than 2.5 million, you do not need an auditor and you can use an independent accountant. So the recordings of today's meetings, we're going to put them on our YouTube channel, PPRA TV channel. I'm going to put it this afternoon. We'll try to download it once everyone has exited. We've shared the slides. If you still have not received a slide, my email address is on the chat. Email me. I'll share with you the slides. Email address for Advocate, it's also here on the presentation. You can, if you remember a question, you can still email us and we will try to respond. If it's queries related to other divisions, you can still email me. I'll allocate it to the managers in those departments. We're going to have, this is important, we're going to have a webinar next week on Wednesday, the 18th of September with ABSA. We were speaking with ABSA Bank because a lot of principal property practitioners, when they send applications, they don't submit a bank letter. They must open a trust account. That process, ABSA will come and explain how they can assist you so that you know what type of a letter it will be, and they will also present on other products that will benefit you as a property practitioner. We posted that link on our Facebook and the invite. Please register because our webinars, there's a cutoff. So next week, we will present on that. I will continue to bring more topics because obviously I have to check what are the concerns. Then now I've noted that there's issues on trust accounts. I'm going to do a webinar with our department so they can come and train you on that. So colleagues, thank you so much for joining. Advocate Vile, thank you so much for this presentation. It was informative.
Thank you, everybody. Thank you for your questions,
yes.
And thank you for your patience with us in the registrations department.
Yes, colleagues, have a beautiful Friday and enjoy your lunch. Thank you. Bye-bye.